Counsel, let me ask you a question about a sentence in Martin v. Mott.
Of course, it's always hard to be asking federal judges to admit that they have no power here, right? You're asking federal judges, human beings, to give up power that they claim.
Where the court said every public officer is presumed to act in obedience to his duty until the contrary is shown, and a fortiori, this presumption ought to be favorably applied to the chief magistrate of the union. So what did the court, in your view, mean when it used the words until the contrary is shown? What does that mean?
Well, I think, Judge Bennett, that part of the opinion was...
So Bennett is trying to find a hook, a foothold here for judicial review. Until the president's presumed to be following the law, until otherwise demonstrated. Otherwise demonstrated to who? Wouldn't that be to a court, is what Bennett is trying to get to, or suggest here. And of course, the response is no, until otherwise demonstrated to Congress.
Addressing the contention that Defendant Martin's pleading was insufficient because it had not set forth the factual basis for the president's determination that there was a foreign invasion in that case. And the court said, no, the pleading is sufficient. The pleading doesn't have to get into that because there is this presumption of regularity that we presume that the president has made the determination. And
but the presumption of regularity, I mean, it's not an axiom of regularity. I mean, that suggests that it is possible to overcome it, right?
I think what the court was talking about there, though, was whether the president had made a determination. So maybe if there was something that overcame the presumption that he had not actually made a determination about whether one of the listed exigencies existed, there could be judicial review of that. I actually don't take Martin to speak to that question, but Martin says expressly that the president's determination of whether the exigency has arisen, so when the president has made a determination that one of the enumerated exigencies exists, that decision is vested in his sole and exclusive discretion and is conclusive on all other persons, including the courts.
Well, actually, Martin versus Mott, the court says when the statute gives a discretionary power that is then based on certain facts. So the court is drawing a distinction between the discretionary decision about when an exigency exists, whether to call forth the militia. But there are two different decisions being made, and I don't see the court saying that the underlying determination of, which is a factual question, of whether the exigency exists is inherently discretionary.
I took the court in that passage to be saying that all of it is vested in the president's unreviewable discretion. And that's why it wasn't even necessary for Defendant Martin to plead anything about whether a determination had been made or what facts underlay that determination.
Well, how do you deal with Sterling versus Constantine then, where the court again then says as the factual predicate, even discussing Martin versus Mott is essentially a mixed question of law and fact that is subject to some review?
So to set the table on this, I broadly agree with the analysis in the stay opinion about both Martin and Luther. And I do think it is, when we get to Sterling, is where I think the court's analysis respectfully went astray. Because in Sterling, there were two issues that the court was discussing. One of them was whether a military exigency existed that warranted calling up military aid in support of civilian authorities. That's question one, and that's the question in this case. Second issue in Sterling was, what was the scope of the measures that they could permissibly undertake once the military had been deployed? Okay, and on that first question about whether the military exigency existed, the court actually reaffirmed Martin and Luther, cited both Martin and Luther and said, the executive is appropriately vested with the discretion to determine whether an exigency requiring military aid has arisen. His decision to that effect is conclusive.
Well, how do you deal with the fact that in that case, what happened was the district court actually made, on a contested record, findings of fact that the claimed exigency as a factual matter didn't exist. The court reviewed that decision said there was no clear error and affirmed on that ground that there was a finding of fact by the district court in that case that the claimed exigency didn't exist.
So I don't understand the Supreme Court's opinion in that case to have affirmed that decision. Again, at page 401 of the opinion, this is what the court said. The question here is not of the power of the governor to proclaim that a state of insurrection or tumult or riot or breach of the peace exists and that it is necessary to call military force to the aid of the civil power. That's not what they were reviewing. They said that the governor's conclusion in that respect was conclusive. What they held
Counsel,
was...
sorry to interrupt you, but let me go to the page before you're on. Let me go to page 400. It does not follow from the fact.
Let me pause there because I see in the comment people want to talk about January 6th. You know, the 5 hours, the 5 hours of tumult that occurred on a single day. First of all, there was no calling out the National Guard. You can't get the National Guard anywhere for a 5-hour tumult. It takes more than 5 hours to get the whole process rolling. So the whole question is irrelevant. Second of all, the president doesn't have the authority to deploy the National Guard to the Capitol building. The Capitol building is the jurisdiction of Congress, not the president. For Pete's sakes, this is not rocket science.
That the
governor's conclusion in that respect was conclusive. What
Okay,
they held
Counsel,
was...
sorry to interrupt you, but let me go to the page before you're on. Let me go to page 400. It does not follow from the fact that the executive has this range of discretion deemed to be a necessary incident of his power to suppress disorder that every sort of action the governor may take, no matter how unjust.
By the way, he just said the word governor, and it reminds me, I should make clear, they're talking about this Supreme Court case of Sterling. Sterling involves when the governor of Texas called out the National Guard because there was a dispute over oil production. The governor wanted production constraints to support price or whatever the argument was. A governor and a president are not the same things. The governor is the chief executive of a state, but each state has its own constitution that governs how much authority a governor has. That's different than a president. It's not the same.
Justified by the exigency or subversive of private right and the jurisdiction of the courts otherwise available is conclusively supported by mere executive fiat. How do you reconcile your position on what the court is saying in Sterling with what seems to me to be a very clear sentence that there is discretion, but that doesn't mean the courts have to turn a blind eye to executive fiat?
So I read that sentence to be discussing what measures the military can deploy once they have been called up. For example, in the next paragraph, I believe it's the next paragraph, it talks about whether the military can be used to effectuate arrests. And the actual question presented in the case was whether the governor could, in essence, declare martial law and by military order limit oil production in the state. So it wasn't a question of is there an exigency that requires...
And that's an important distinction too, right? I mentioned that Trump federalized the California National Guard here and also in Oregon under this statute 12406, right? Rebellion or danger of rebellion, unable with the regular forces to carry out federal law. 12406 does not set aside posse comitatus. It does not allow the federalization of National Guard for law enforcement purposes. But there are means of federalizing the National Guard that do set aside posse comitatus, such as the Insurrection Act. Trump didn't use the Insurrection Act here, but had he done so, then he would be able to use the National Guard for law enforcement functions. So it's a question of not just when can you call out the National Guard, but what can you have them do? Under 12406, you can use them to protect federal personnel and property, but not to make arrests. Under the Insurrection Act, you can call them out, deploy them, and you can use them to make arrests as law enforcement.
There's military aid. It was...
And of course, the fact that at the federal level, we have these two parallel ways of federalizing the National Guard, but each has a different scope of use, permissible use of the Guard. At the federal level, the fact that they're talking about a state case here involving the governor of Texas begins to distance the applicability of this Sterling decision and what's happening here at the federal level.
What are the measures that can be taken? And does that extend to having a military order limiting oil production. And we do have another case that's coming up behind this one about the measures that are taken. But this case is solely about whether the exigency warranting calling up the National Guard existed in the first
Well, it
place.
literally says there was no exigency. I mean, that just the court at 404 is affirming the district court's finding that there was no military necessity, no exigency, which justified the executive action.
I think it's that last part is the key, Judge Sung, which justified that action. The military exigency that they didn't question, they said the governor's determination was conclusive, couldn't justify the measures taken to limit oil production.
So the parallel here would be Trump's activation of the National Guard under 12406 does not authorize him to use the National Guard as law enforcement. It doesn't. It doesn't set aside posse comitatus. Had he federalized the National Guard under the Insurrection Act, he would have that additional authority.
Suppose that I guess if we were to agree with you on this, that's the end of the case, but suppose we don't. And the stay opinion was somewhat ambiguous on.
So the stay opinion was this 3-judge panel's prior decision on this. Remember, Judge Breyer in San Francisco had issued a temporary restraining order against Trump, saying Trump exceeded his authority under Statute 12406. And this 3-judge panel unanimously stayed that injunction, froze that injunction so that Trump was able to deploy the National Guard to California. And essentially what they said in the stay opinion was, look, we reject that there's no judicial review here. We believe we have the authority to review what Trump has done here. But our review, the judicial review, needs to be super deferential to the president. So as long as there's even 1% facts that could support the president's decision, we have to give deference to the president. But if there were zero, if there was this claim of a rebellion or danger of rebellion, or this claim of being unable with the regular forces to carry out federal law, if there was zero evidence to support that position, we would have the authority to issue an injunction against the president for calling out the National Guard. That's the essence of what they're referring to as the stay opinion, their own opinion that stayed the district court's TRO against Trump initially.
Exactly what level of interference with the normal execution of the laws is required to satisfy 12406 paragraph 3.
So now they're getting to the question of 12406 paragraph 3 is the one that says the president can call out the National Guard if he's unable with the regular forces to carry out federal law. The trial judges have been saying unable means utterly unable. If the president tries to carry out federal law even once, if he tries 1,000,000 times, and fails 999,999 of those million times, but he's able to carry out the federal law even once, well, then he's not unable. He's not unable. Obviously, a very stretched reading of that language, but that's the question they're getting at here. I would argue that if the president's ever unable, even once in 1,000,000 times, to carry out the federal law with the regular forces, then he's unable.